Good morning, everyone, or good afternoon, everyone. All protocols observed. My question is on a situation where the confessional statement is recorded by the police without the use of the word shall or may, and the confessional statement is tendered in court and admitted. In a situation where there are other cogent and convincing evidence to support that confessional statement, what comes out of the confessional statement that was not recorded in accordance with the may or shall? I hope you've gotten my question, sir. Yes, so this is my question.
Thank you very much.
Thank you. Mr. Chairman, sir, all protocols duly observed. I just want to draw attention to, I'm speaking now directly to Madam Professor Agile. I think the more radical and more appropriate interpretation of Section 15, subsection 4, the first time that was done, I think might have been in Charles against the Federal Republic, where Justice Akanem took time to go back and look at the harm that was supposed to have been cured by the Administration of Criminal Justice Act and the decision, as you quoted, the obiter of Honorable Justice Rhodes Vivor in Oyewure against COP, to come up with the suggestion that even though the word may was used, but because it was for the protection of the right of a citizen, it must be construed as being mandatory. I think if that approach had been adopted, which is to cure the mischief that was there from time immemorial, we wouldn't have run into this problem of divergent or conflicting decisions of both the Court of Appeal and the Supreme Court. So I think, as you have said, my Lord, sir, I think the position now taken by the Supreme Court in Nigeria 4 is just in keeping with the essence of what was supposed to have been done. And I think it ties into what Mr. Law has said. It saves the time that we waste in trials within trial, which goes to achieve the overall purpose of the Administration of Criminal Justice Act, which is to enhance speedy dispensation of criminal justice. Thank you.
Thank you very much for that contribution, Mr. Abdullahi, Senior Advocate of Nigeria. Can we have further contributions? My Lord, Honorable Justice Odo. Thank you, sir.
Good afternoon, my Lord. Good afternoon, the presenter and everybody. Actually, my position is just, there is a comment. Because the issue, based on these conflicting decisions of the Supreme Court with respect to Section 15 and 17 is, what should be the position of illegally obtained evidence? Evidence obtained contrary to the provision of the law or statute. We know before now that the Supreme Court have said in various judgments that the evidence obtained contrary to the provision of the statute or illegally obtained is admissible. The rest goes to the waste of attached to it. Now, in this Nigeria 4 and state, yes, the decision is very clear. The reasons given is that whenever a statute imposes a duty on a public functionary to act for the benefit of private citizens, may shall be construed as shall. But in another Supreme Court case called Musa Sadao and the State that decided earlier, in that case, there was also a duty imposed on a public functionary, a police, to act for the benefit of the citizens. In that case, that it dealt with the section 78 of the Criminal Procedure Code, which says that before you conduct a search, the police must do so in the presence of two adult respectable persons. And the search was conducted without compliance with that provision. When the evidence obtained during that search was to be tendered, there was an objection that the statute, the CPC, was not complied with. Then the Supreme Court said, what they said, one, is that the test to be applied in considering whether evidence is admissible is whether it is relevant to the matters in issue. If it is admissible, and the court is not concerned with how the evidence was obtained. Number two, if the proper procedure was not followed, the consequence of the irregularity will attach to the persons executing the warrant and not the evidence which is thereby obtained as relevant to the case. So that is the position, and there's other cases that followed it up to Taiwo. Now, my question is this: when it comes to, because in a court we always admit, police bring evidence that are obtained without compliance with the provision of a statute, just like section 17 and 15. In this case, the law we used to apply is that even though it's illegally obtained or against the provision of statute, is still relevant. Yeah, we still admit it, and at the end of the day, you consider it with the light of the other evidence before the court and know whether or not you will attach weight to it. But in this case, in Najafo, is the moment it is not compliant with section 17, it should be thrown away. My question now, is that the general principle for an illegally obtained evidence? Evidence obtained contrary to the provision of the statute. Is it that should be the law guiding such admission of such documents, or is it restricted to only section 15 and 17 of ACJA? Because we know that most of the evidence the police bring before the court, most of them were contrary to the provision of statute, the law, whether procedural or substantive or not. Most of them are, most of the time, is against the provision of law. Who continue to reject it based on the case of Najafo and Federal Republic of Nigeria? That's my question to the presenter. That's number one. Number two, the issue now, as my learned son said, that they comply with this section 17 will help to reduce the issue of trial within trial. Now, we should not overlook about the process of that admissibility. When a prosecution witness is giving evidence and wants to tender confessional statement, and the defense counsel says, no, it would not be admissible because it is not comply with the provision of section 17 of the ACJA. Would the court automatically admit it without hearing parties to know whether or not it was obtained without compliance to section 17? Because I know in the provision for procedure for trial within trial is that once there is the issue of involuntariness, then the prosecution will start to call evidence to prove beyond reasonable doubt that the statement was voluntarily obtained. In this case, there's an objection that there was no compliance to section 17 because no legal practitioner, nobody was there. Would the court go and just because it was said so and admit, or go to hear both parties? And if you have to hear both parties before admitting it, obviously we are going towards trial within trial again.
Thank you very much.
Thank you,
sir.
please.
Thank you very much, sir. Before we continue with contributions from here, we would like to take some contributions online. The coordinator of Rule of Law Development Foundation, Mr. DAUDU, Senior Advocate of Nigeria, would like to make his own contribution.
I greet everybody and commend this session. It's been very vibrant and very enriching. I just want to make one or two points, and in the process, interrogate the issue, the very pertinent point raised by my lord from Kano State High Court. In answer to her question, she has asked what happens in the event of there been available evidence to support or corroborate that confessional statement that was jettisoned because of involuntariness? I think the answer to this is very simple. There are two streams of knocking out or approaching a confessional statement. The first is when you retract the confessional statement. The accused person does not challenge it on voluntariness, and thus goes into the witness box to say, I did not make the statement, I just was made to sign, or I disown the statement, I don't know anything about it. In such a situation, that situation is called a retraction of a confessional statement. And there's a long line of cases, starting from the 1958 case of Aclrc against the Queen, leading to more recent cases on it. When that situation happens, that statement is admitted in evidence. It is only when it's only in that situation that the court now applies the 6 tests that arose from R against Sykes, Kanu against King, and the Plateau case named Mitsu, and more recent cases in which it will now ask itself 6 relevant questions. Is the confession corroborated? Is it true? As far as it can be applied to the facts, there are facts outside the confession that make it to be true, on and on until you get to the 6th question. So it is only a reduction that you apply the question of whether there is evidence outside it. Now, when there is a challenge to the confessional statement, the issue of voluntariness, involuntariness, and that challenge is upheld, the statement goes. Once the statement goes, any other evidence will be considered on its own weight, not by reference to the confessional statement, because it is now deemed in law that the confession was never made, having been obtained involuntarily. If there is evidence outside the confession which points to the guilt of the accused person, oral, direct, or circumstantial, the judge is entitled to perfectly discard the confessional statement and rely solely on the admissible evidence for it, without making any further reference to that confessional statement that has been jettisoned. So I think it was important to draw attention, at least to the extent of my own knowledge in practice, of the fact that there are 2 different streams on this. Now, going to Justice Odo's very, very relevant point on the case of Sadao of Kunya against R, the 1969 case, in which the Supreme Court refused to evidence after the confessional statement had been expunged, to jettison statements, exhibits that were found. In that case, I think the murder weapon was found where the statement, even though the statement was obtained involuntarily, the Supreme Court still applied that piece of evidence to convict Sadao of Kunya. Now, in America, that would not fly. It has the name of the doctrine. It has one name in which every piece of evidence that is tied to an illegal site, an unlawfully obtained confession, or is jettisoned. So no conviction will stand in the US where the original document goes. But the long line of cases of Sadao, 1969 Nigerian Mountain Law Report, and other cases that have followed it, Our courts have been consistent. Now, the drawback is this. Because I've upheld that line of thinking, it has stunted the ability of our police and other investigation bodies to carry out forensic investigation in solving crimes. Because if you eke out or you obtain involuntarily a confessional statement from a suspect, you are rest assured that exhibits that you recover from that statement will be admitted in evidence and are liable to be used to convict the said accused person. However, if we had followed the American system, which throws out everything, statement and all exhibits found pursuant to it, it would have made our police, with due respect to the DCP Simon Law, to engage more in forensic investigation rather than waiting for the witness to confess. I think it's time that we step up. Our police have the capabilities, the capacity to carry out forensic investigation. When they go out of the country, they are always listed as the best. Their attitude changes only when they come back into the country. But we know that we have well-trained men and women in the Nigerian police, and people in the leadership like DCP Simon, they should talk at their level for them to enhance the prospect of forensic investigation. It is expensive. Crime scene administration, the use of fingerprinting, the use of all the other scientific gadgets, which will solve a lot of crimes and deter criminals. So that's just my contribution on these two main points. I thank you very much.
Thank you very much, sir. Coordinator, Rule of Law Development Foundation. Thank you very much, sir. Before we take more contributions, we'd just like to get the response of Honorable Justice, Professor. Okay. My Lord wants to has a meeting.
Okay.
Oh, sorry. Good afternoon, my Lord, Honorable Chairman, other members of the conference. Mine is just a comment. I want to appreciate the speakers this morning. We really learned a lot. I had a lot of questions before today, but from what I heard from the presenters, all my questions have been answered. And I pray that we'll get the papers before we leave. I pray. At least it should be an encyclopedia for us. In Kano, the situation is a bit different because the issue of, I've gone through the law, we have the issue of electronically taking statement from suspects. What we have is that the statement should be taken in the presence of a legal practitioner. If he's not available, in the presence of a legal aid counsel or an official of a civil society or any other person of the choice of the suspect. So I don't think, we don't have that problem in Kano. I think it's easier for us, but I will appeal to the police that please continue sensitizing your officers, because up till now, they are not abiding by these provisions of the law. There are simple provisions that can be done, but whenever they come, they don't do all these things. So we find it very difficult sometimes. Like now we have two contradictory cases. One is saying that me is not compulsory, is optional. The other one is saying that it's compulsory, and it's fatal if it's not done. What of in a situation when a prosecutor seeks to admit such a statement? What will you advise? Should we reject it in total, Or should we just admit it and then the weight to be attached to it is something different? Thank you.
Thank you very much, my lord. Thank you.
Thank you very much. Please permit me to stand on existing or sit on existing protocol. My first comment will be on section 17.2 of the ACJA. A lot has been said about confessional statements, but if we look at that provision is not even talking about confessional statements. If you look at 17.2, 17.2 talks about the extrajudicial statement of a suspect. So even the objections, because now I have also seen it in practice, people are now extending the objections even to statements that are not confessional statements. As long as they look at the statement and cautionary word has been issued to the person who made it, objections are raised that there was nobody there at the time that statement was taken. And as a result of that, and then they cite in Najofo and say, these statements cannot be admitted. So I'm just going to give the police that hint that this is also happening now. So if you have any other extrajudicial statement that is not even confessional statement, practitioners are now beginning to apply these rules to those statements. My second point, I had wanted to ask the question to Professor Hon, but he's no longer here, so I'll transfer my question to Professor Ajile. If we look at, because of his comments on Tumbido and INEC on dumping of documents, where he stated that if it is a video recording, is a CD, that the court should not apply the rule on dumping. If we look at the interpretation of section of the Evidence Act, specifically section 258, if you look at the interpretation of documents there, it includes tapes, recordings, discs, CDs. So do we not see the wisdom of the courts in also applying the rule on dumping to that particular, to CDs, and also insisting that someone should demonstrate? I give a brief example. If, for instance, someone is killed and there is a video recording, maybe CCTV of that incident, or there is an accident and there is a video recording of that incident, and you just come to court and say, my lord, we have it on video, and then you just play the video and that is it. The court may be found to be jumping into the arena if nobody speaks to that video and says, this is the defendant in this video, he's the one wearing this red t-shirt, this is the victim, this is this person, and this. If you don't do that identification, I feel that the court will be correct to say that you have dumped that document, and the court cannot on its own reach the conclusion that this is that person. For all you know, that could be a different video of another incident that may be similar but not representing that particular situation or that particular circumstance. That's my contribution. Thank you.
Thank you very much. My lord, there's just one more question. Okay.
Sorry.
So you
actually, what will happen, I can leave my number, so that even from LOKOJA and now, I'm sure they have some questions, but they have my number. They can easily reach me. But others, the chairman will give you my number, because at the Nigerian Institute of Advanced Legal Studies, they are waiting for me now. I should be on my way by 12:30. So I have just 6 minutes to leave this place. But I'll be available to answer any question. I want to begin with Chinelo. Yes. I think the point that Professor Horn was making was that before that decision, the Supreme Court took a position that disc, video, and what have you, that they are documents. But he was surprised that in that case, the Supreme Court was trying to distinguish between real evidence and document, which is a distinction without a difference. And as a matter of fact, before that decision, there had been an earlier decision in Silva and Dixon, where the Supreme Court itself, Wednesday, JS of blessed memory, clearly stated that if you tender electronically generated document, e-document, he calls it e-document before the court, without displaying or demonstrating it, it is like dumping. And the principle of dumping is not a new concept. It existed before the era of electronic evidence. And so I think that was the point. He was expressing, I know, we continue to express surprises too, you know, over many of the decisions of the, with due respect of the Supreme, as we are seeing. So Section 258 of the Evidence Act defines what a document is. And it is defined in terms of inclusiveness. It does not say document is or document shall be. Rather, it says document includes and begins to give a list. Amongst we say it includes film, video, tape, what have you. And there is no end to it because of the word includes. So I think it was querying the decision of the Supreme Court in that sense, and dumping well-established principle which cannot be altered. The court cannot go back in his closet and be watching video and will come in his judgment to say, this is what I saw. And it's different from what is in there. If it was not demonstrated clearly before it, because a court is not an investigator. An investigation is not the duty of the court. Duribiniya and COP established that long time ago. Beth J, a colonial judge. So now, Leonard Sig, the coordinator of Rule of Law Development Foundation, I think has answered the question of Justice DAUDU. Has also answered the question of my love from Kano sufficiently. And Yahya SAN, I think he also made a very valid point, which I don't think anybody can dispute regarding admissibility of confessional statements. Essentially, they are meant to facilitate speedy demonstration, administration of justice in a way that delay will no longer be caused. But what the DCP said, I don't know, to say that ACJA has abrogated Section 29. Yes, imply repeal. I don't think we can imply any repeal of Section 29 by ACJA. Like we said, the two should be seen as complementary. Section 29 says, before you admit any confessional statement, make sure it is voluntary. And if the voluntariness is challenged, if it is said to be voluntary, then you can go to trial within trial. ACJA now came to say, like complementing it, if you are taking confessional statement, video record it and bring it to court. And by that, it's like supporting what Section 29 is saying, that this is the evidence I have to show that the statement was made voluntarily. And the video is here. It is for him to say the video live. And there will be no need for trial within trial. So I think the two should be seen as complementing one another and not repealing one another. That's my view. Thank you very much.
Thank you very much, Professor Alabajile.
So, gentlemen, at this point, you will allow me to help. I'll take his, my Lord's number, and I will be ready and willing to give it to participants who wants to, get in touch with him and for more clarification or answers to questions. So, yes.
Copies of the, I'm sure Chinelo is there, how they can get copies of these lectures. All right, good. Even if it is electronically.
My Lord, we thank you so very much for sparing your time and for giving us out of your wealth of experience. God be with you. God bless you. Thank you so much. So before we round up, I think it is just proper for us to take comments or questions from Glasshouse and among ourselves to deal with it before we call this session to close. Yes, now and we see what we can do.
Can we check Glasshouse? Mr. Abdul, could you please give us an update if there are questions from the Glasshouse?
To me, my own submission is these provisions are clearly not what is not within the are clearly not within what the police or other security agencies cannot achieve. I think, especially in this era of smartphone, that everybody holds a smartphone these days. If you arrest someone and the person voluntarily want to render a confessional statement, a police officer or any security officer can easily bring out his or her smartphone and record the confessional statement. And in the process of tendering such statement, you can as well tender such recording from the phone, having complied with the provision of the Electoral Act, provision of the Evidence Act pertaining tendering of electronically generated evidence. So this is which I totally agree with the decision of Supreme Court by Ogumiju JSC when he said, look, there is no excuse by either the police or any other security agencies to say that they cannot comply with these provisions. It is, especially this era that we are, it is very easy to comply with, and all this issue of trial within trial, I made the statement or I did not make the statement, will be laid to rest. That is my humble contribution. Thank you very much.
Thank you very much, Mr. Abdul, who is speaking to us from the Glass House of Kogi State. Thank you very much for your contribution. Before we go, we just want to make sure we get through to everybody. Please, your contribution, please.
All right. Thank you very much. All protocols duly observed. So my question basically, okay, my name is Emmanuel Damlari Lawal. Yes, thank you very much, sir. So my question is that the provision of section 15, 4 of the ACJA and section 17.2, whether they are to be complied with simultaneously or alternatively, because if we check the provision of the ACJL, the Lagos 2011, it appeared to clarify that position that it is only where electronic recording is not available, that is when the presence of the legal practitioner will be necessary. But however, the ACJL, the Lagos ACJL was amended in 2021. And now the section 9.3 have now been amended and the two conditions have now been bifurcated. We now have section 9.3 and section 9.4. While section 9.3 provides for the electronic recording and it uses the word shall. But section 9.4, which provides for the presence of a legal practitioner, uses the word may. So I want to understand the distinction, whether it's supposed to run concurrently or alternatively. Why the ACJL clarified before, but the conjunction have now been added in the new, in the amendment of 2021. So in our ACJA 20, in our ACJA in Abuja, we will notice that it was not also clarified whether it's supposed to apply concurrently or alternatively. And just like one of the speakers mentioned earlier, that if we look at the provision of section 17, we will see that it only applies to statements and not confessional statements. In my opinion, I believe that all confessional statements are statements, but not all statements are confessional statements. So, and we also have to look at the downside that if you are saying that we have difference between confessional statement and statement, at what point do you start to see confessional statement from statement? Is it at the point where the defendant is making some admission of guilt that you now say, oh, let us set up a video because this seems to us like a confession? So, in my opinion, I feel like they should both should be complied with, and I feel like there is need for the law to also explicitly state it. So, back to my question initially, that whether it is supposed to be complied with concurrently or alternatively. Thank you very much.
Thank you very much for your contribution, Mr. Lawal. Mr. Hyginus Ibega, contribution, please. Please make it very quickly.
Good everyone. I want to stand on the existing protocols. Hyginus Ibega is my name. My own opinion on submission with respect to all we're discussing is this. From the tenor of our discussion, it will seem to be that, now that the Supreme Court have said there must be a recording. We might be, for the judges or those in the bench, it might be tilting towards the position that, once there is a video evidence, it should be accepted as being voluntary. But I also want to say that there could also be an instance whereby somebody makes a statement on video, yet it's involuntary. It's possible. The police can arrest somebody and tell the person, promise him, say, we're going to cover you. If you watch some of these child trafficking videos or stuff like that, somebody can be told they are going to interview you. As they're interviewing you now, say so and so thing. So it doesn't mean that once there is a video evidence of what transpired, it is voluntary. I'm trying to say this because if we begin to think that once there's a video evidence, we should accept it. Somebody can still come and say, no, before this video was made, I was giving this promise. In fact, I held an instance. You know, ice block. If you sit on ice block or you hold ice block, in the next 5 minutes, you will not be comfortable. I've heard of instances where in a police station there's an ice block and the person to be interviewed was made to sit on the ice block, covered with maybe leather or something. In the next 4 minutes, you discover that the blood will cease to flow in your veins, and the person can make any kind of a statement. So I am saying that in as much as we are beginning to think, we commend the Supreme Court, I also want it to be in the back of the mind of prosecutors, judges, and even defense counsel that video evidence can still be made, yet there is involuntariness. That's my submission.
Thank you very much, Mr. Hajin Sibega. We'll now take responses from DCP Law and the chairman.
Thank you, Mr. Chairman. I will first of all start with the question asked by the judge from Kano State with respect to the fact that the ACJ of Kano didn't make provision for electronic recording, but rather make provision for the presence of a lawyer. That issue has been taken care of by the case of Ajiboye versus the state. In that case, Ajiboye versus the state is in 2018, 13 Nigerian Law Report Part 1637. In that case, the Supreme Court held that it is not mandatory that the lawyer must be present. It's not mandatory that the lawyer must be present. What? Okay, it's okay, sir. So yes, and with respect to my last question concerning the issue of recording statement in the presence of a legal practitioner, the case of Ajiboye versus the state has settled that issue. It's in 2018, 13 Nigerian Weekly Law Report Part 1637, page 430. In that case, the Supreme Court held that it's not mandatory. It's not mandatory that a lawyer must be present before a statement or confessional statement made will be admissible. So I think it has taken care of the Kano situation. And with respect to the other barrister who was saying that that is evidence recorded in the video need to be demonstrated in court. That is the correct position. There are cases which have been prosecuted where CCTV cameras capture the suspect in action. So it was the responsibility of the prosecution, that is we now, to show the court who among the suspect in the dock were in that video, because the video was played, the CCTV footage was played in the court. And the IPO had to identify, yes, this is second accused, this is second accused, for the court to know who were in those CCTV footage. So to avoid the issue of dumping, so it is mandatory and it's necessary. We have been doing it. Even in the case of but the same thing that we did it here. They have to demonstrate who were the persons involved in the killing. And then the position of the Lagos State, as asked by Lawa now. You see, before they used the word may, now they use the word shall. The issue there is that the Supreme Court has 3 decisions, current decisions, and courts are bound by decisions, lower courts are bound by decisions of the Supreme Court. So we have now three decisions. We have Charles and the state, we have Najafo versus Federal Procurator of Nigeria, and then we have Aclrc. So these are recent decisions of the Supreme Court, and as far as the law is concerned, they remain the position of the law. The position of the law as it is now is that those provisions are mandatory. That is the issue. So until the Supreme Court departs, and it is important that I took the hint of my Lord where he raised the issue of Sadao. We test that issue because it is important for the Supreme Court to know that it has either taken decision that no matter how evidence is obtained, it's of no moment. It's of no moment. Once it's irrelevant, it's admissible. So if we now argue these 2 positions, that previously they have held that it does not matter how evidence is obtained. So those evidence were also obtained not in compliance with the law, just like the way statements recorded are not in compliance with the provisions of the Act. So so that we will know. Because in all these cases, those cases were not cited. They were not even referred to. So, but we will have the opportunity of advancing the law by bringing those cases in now, so that when the court decides, we will know the clear position. As it is now, there's no clear position, and as it is, we are neither here nor there. Even on the issue of the Section 15 and the 17. Still, we have conflicting decisions, even though we have 3 recent decisions. Then, with respect to the issue of, my Lord also raised the issue that confession that was taken not in compliance with the law, but was voluntary, what should be done? You see, we have situations where even when confessions, it's a case that we're even conducting trial within trial now. The confession was recorded in writing, it was interpreted, it was video recorded, and yet the defendant said that it was not voluntary because they were tortured. So whereas involuntariness is raised, it is mandatory that a trial within trial must be conducted. So it has to be conducted. It's at the end of the trial within trial before decisions can be reached whether they are voluntary or not. So it's not just the issue of that they were, taken in writing, video recorded as provided by the law. Even then, lawyers have raised issues. In fact, there are so many cases that have issues that have been raised. That is where the statement was recorded in compliance with the provisions of the law. So it is for the judge to now, apply the provisions of Section 29 to determine the voluntariness of the statement before such statement can be admitted. And I was making allusion to the issue of implied repeal. When I say the doctrine of implied repeal, has impliedly repealed Section 29. I mean, when the act of two act of National Assembly on a defense on a subject appear to be conflicting. The latter in time prevail. The latter in time prevail in the sense that Section 29 and Section 15 and 17 of the ACJ appear to be in conflict, even though not completely in conflict. I said they are complementary in my own paper. I said they're complementary. But to others, they may say they appear to be in conflict. But where they appear to be in conflict, the later in time will prevail. That is the doctrine of implied repeal. I think that I've taken care of all the other questions that have been said. There's anyone. So that is what I have for now. Thank you.
Thank you so much for your response. I will use the power conferred in me by allowing, yes, as the chairman, by allowing DC Alani Senior Advocate to clarify one or 2 points for us in our bid to at least learn as much as we could.
Thank you very much, my Lord. When my Lord from Kano drew our attention to the provisions of their own AJCL, am I correct, my Lord? When was that law made? 2019. I have a problem with wholesale application of the Supreme Court judgment in 2018. Now, the wordings of your law will appear to be that the lawyer will be there, civil society organizations will be there, legal aids will be there. I know. Now, that law should be interpreted the way it is. And the law, as you have stated in 2019, was simply that any of these must be there. Therefore, it is compulsory. Where the Supreme Court gave judgment in 2018, which was referred to in relation to ACJA, Supreme Court was interpreting the ACJA in its context. Kano, the provisions of ACJL of Kano differ slightly, if you recall very well. After the enactment of ACJA, states were asked to domesticate these laws. Domestication does not imply wholesale importation and implementation. So my opinion is this: that Supreme Court judgment that says once it does not comply, you cannot take it, is slightly different from what your own law in Kano, ACJL, is talking about. So my opinion will be this: where there is non-compliance with the ACJL of Kano, which was a law made after the 2018, the provisions of that Kano should be applied independent of the judgment of the Supreme Court. Thank you.
Yes, I have been hinted, and I know we will be enriched by your contribution. So, Learned Senior Advocate, please, let us have your mindset.
My Lord, participants, I just want to add that every judgment decides a case before it. The case, in interpreting or finding an authority, you need to know that the judgment was based on a law that is similar to the one that is in question. Now, the ACJ, the domestication in different states, has different inputs. So a Supreme Court judgment, maybe that decides the one of Akwa State, will not necessarily be an authority for the one in Kano State, except those laws were on all fours. So there could be, in judgments, there could be distinctions. When you look at the judgment, you look at the law that the court decides on, you will look at it whether it's on all fours. If there are differences, you have to apply the differences, because those are laws made by state. It's not just one ACJA, it's the federal one. The federal is there from the states. And the state can put and impute things that they think are domestically relevant to their environment. Thank you very much.
Okay, thank you so much. Distinguished participants, I thank you so very much. I just want to again make one slight contribution on this issue of dumping and not linking evidence. You see, we are in a modern era of technology. We all know the harm and the mischief and machination that can be generated by artificial intelligence, deep fake, photoshopping. So when you don't draw the links and link the dots, a lot of havoc or harm can be done. So like we said, this morning's session, the topic is very, very burdensome, cumbersome, troublesome, and it can determine whether the justice of administration of justice in a criminal matter will be met or it will be truncated. So I thank you very well for your participation. You've been active, and we thank all the presenters. We are all better informed and enriched. There will be announcement from the organizers on the what next. Thank you so much. God bless.
Thank you very much, Mr. Chairman. Before we draw the curtains on the first session, we just want to recognize the presence of Mr. Olumuyiwa Akimbo, Senior Advocate of Nigeria. Please let's give him a round of applause. Thank you for coming. We also want to recognize the presence of Mr. Adedayo Adedeji, Senior Advocate of Nigeria. Thank you for gracing us with your presence. We shall draw the session to a
take a good photograph. Yes. Please, let me, my lords, please, we want to have a group photograph by the banner there. Please, yes, we would like to have a group photograph. Please, please, let's have a group photograph here just by the banner here.
My lord,
thank you.
Could you just wait and take one more shot? My lord.
Please, let's have a group photograph, please. Let's have quickly. Then we can now proceed to take our breakfast. Mr. Hassan, I can see you've already commenced the proceedings. Please let's have a group photograph. No, please let's take it quickly and yes.
shine. The young lion hunger and suffer lack, but we that trust in him never want of a good thing.
Tell me what you see. All the suffering, no be so we supposed to be. Children hungry, many mouths they to feed. A little tolerance, that's all we ever need. Rise up Africa, we need to fight for just cause. Nepotism don't put us for great loss. Confusion, the brain frustration. Put it to a situation, hold us to ransom. Africa is time to stop live for dungeon. Good condition, not just a random. Vexation, live for we generation. Guns of bombs, they kill with nation. One love, honest, they go bring the freedom. No hallucination, 2020 vision. Togetherness must be with nation. Yes, wake up Africa from the slumber. Hold on, be strong. You got to be wise, be right. Hold on, be strong. You got to be wise, be right. Rise Africa, we need to fight for just cause. Nepotism will put us for great loss. Confusion, the brain frustration. We need to cause situation.